It's time for episode 2 of the Johnson & Johnson Pinnacle hip replacement scandal. Has your lawyer lost your case? Is your case already lost and your lawyer's trying to hide it from you? It's very possible. Mine did. I'm Glenn, I'm your host, and I'll see you every week right here. We can just sit down together like this and go over it, but here's where we left off from last week. We discussed how the Johnson & Johnson Pinnacle is a hip replacement device, artificial hip, and lots of us got them in the 2000-2010 period, and Johnson & Johnson basically described them as the greatest thing since sliced bread, and they were unlike its previous iteration, which caused everybody pain and suffering and got settled out of court for hundreds of thousands of dollars to everybody who got one. This one was absolutely perfect, they said. No, couldn't cause any problems, and everybody who claimed, like me, to be suffering from it was a leech and a liar. Okay. So that's what went on. And remember, what I'm trying to do here is to warn you what happened to me, and I actually have no knowledge of the facts. I don't know if you even have a case, and I'm not a lawyer. I'm not giving you legal advice. I'm telling you what happened to me so that you can hopefully make sure it doesn't happen to you. But I am not hurling any criminal allegations at anybody. I'll do that in private. And I am not hurling any civil wrong towards anybody. No. I'm telling you what happened, and you can go about trying to find out if that affects your case the same way it affected mine. So we're back to, what happened? Okay. Well, as the numbers of people who, we're talking about 2010, 2015, as the number of people swelled, and claimed that they had pain in their hip from the Johnson & Johnson Pinnacle, Johnson & Johnson really radically denied it, offered nothing, not even dirt to go away, and basically impugned the integrity of all of the people who claimed that they were in pain from the Johnson & Johnson Pinnacle hip replacement. Well, it got pretty nasty, and so finally a judge in Texas, in Waco, Texas, I believe, sent to all of the courts, this is a federal judge, so he overrules all of the state courts, and said, we're going to settle all of these cases, we're going to hear all of these cases in my courtroom in beautiful Waco, Texas. It's the Fifth Circuit, come on down, everybody sends their case here. This is not a class action. And so all of the cases were put in a huge vat in Waco, Texas. I had hired a lawyer out of Waco who my doctor, the one who put in the bad hip, referred me to. And that's always been odd. I don't know why I would take the card of a lawyer who has his doctor. What? But anyway, he did file the lawsuit, so he got me into court, which is really important, because boy, are you dead if they don't do that. But the secret that I'm trying to hide or hold over till the last minute of today's episode, and why it is that you have to right now check what's going on in your case if you have one of these 10,000 cases, is that my lawyer then did nothing. Just opened the file, put my name in it, put the retainer in it, put the little letter they send out saying, here's what you can do, which was really terrible. They didn't even send me a letter saying, by the way, right now you should start a diary so that every day when you experience pain in your hip and you fall down or you look stupid in public because your leg gives out, we can have a record of each one of those that happens to maximize your recovery when we go to trial. They didn't even do that. But to give away the ending a little bit. So my lawyer did not do anything. No depositions, no requests for admissions, no interrogatories. They did not do anything. So that's why when 2018 rolled around, and my lawyer was thinking, I'm sitting pretty. Johnson & Johnson, if they give money, I'll tell my clients I'm a hero, and this is all we could have gotten. They'll settle for it, and I'm a hero. Get a little bit out of each one, and apparently they claimed, and I heard this claim with my own ears, his firm claimed to have 200 cases. Okay, so let's say his fee is, he gets $20,000 on each case. They average $60,000. So 20,000 times 200, I think that's about $2 million. Yeah, so he gets $2 million for doing nothing but sitting around in his office, sending out a few letters, and just waiting for the money to roll in. Brilliant plan. Definitely illegal because it means that he's neglecting my case, which is unethical, and violates our contract that said that he would litigate the case and research it and do all the things that you do when you're a lawyer. No, he just had a big pile of cases, and he said, I'll just get a little bit on each one and not have to do anything. And then the gong hit. He was in the court, and I was watching TV. It's funny, I actually enter into this huge case just quickly. And I saw on TV an article about Johnson & Johnson had two whistleblowers, and that, as I said last week, they had come out and said, we don't have any machinery for measuring these hips, and we have been sending you whichever one you've got. We did not know if your doctor said we need a 56. We didn't know if we were sending you a 56. We didn't know how to measure it. We just sent out whatever we had. So if it doesn't fit now and you limp, it's our fault. So I called my lawyer, who was in the court, and pretended that he was part of the trial that was going on. Now, I should back up. There had been one trial already, a woman who'd gone to court with just her one lawyer and with no evidence and no experts, and just said, my leg never hurt before they put in the Johnson & Johnson Pinnacle, and the minute they put it in, it's hurt, and it's hurt ever since. And they went on a theory called res ipsa loquitur, which means that, hey, the thing speaks for itself. Didn't hurt before, hurts now. Got to be the thing. Well, juries in Texas are tough, and they gave her no money. And she lost. So the judge, thinking, I'm going to just get rid of these cases now. Johnson & Johnson's in the bird seat. They think, hey, these cases aren't worth anything. The public knows it. The public will take anything we give them. So, yeah, Judge, we agreed to do 5 trials at a time. We'll just crank them out. So the next one in 2018 was 5 people who went in there. But while it was going is when these people, these 2 whistleblowers at Johnson & Johnson were on TV. And I called my friggin' lawyer right away, and they gave me his cell phone number in the courtroom. And luckily he had it off. But I called him and got him and said, the reason these things hurt, and Johnson & Johnson has not told us, but the reason they hurt so much is because they are not the right size. And I told him about what the whistleblowers are doing. And he told the lawyers up at the front, there were 5 of them for their 5 clients who were taking their cases to trial. And the judge called a break for the day, and they came back the next day, and the plaintiffs and the judge agreed this was a case for punitive damages. In other words, this was a case where if the jury awarded damages, which it looked like now they would, because now we know why they hurt, and that we also know that Johnson & Johnson was lying, and also that they were intentionally doing things that caused people to hurt, that meant that the jury could award punitive damages. And remember, punitive damages are based on the wealth of the defendant, not on how much it would mean to the person who's doing the suing. So if the defendant is worth $1 billion, like Johnson & Johnson, punitive damages in order to cause Johnson & Johnson some serious pain would have to be what? $100 million? So the first 5-pack, which is really a second trial, commences. That's where I call my lawyer, tell him, he goes up to the lawyers at the front, tells them there's a break in the case. It's funny, I enter into this case, and the next day the judge says, okay, well, when this trial is getting ready to hand the case over to the jury, where I'm going to read them the jury's right to give punitive damages, what they would have to do in order to find that they're proper, and we will go from there, which I thought was the greatest day in my life. That would make this case the best case possible. But not if you didn't do anything with the case, not if you weren't ever planning on going to trial and you were hiding that from your client. If you were a lawyer who actually didn't do anything with the case and just figured your clients will never know, boy, you got to be sweating now, because now your client's going to find out you didn't do anything. So that's exactly what happened. So they continued with the trial, and finally it came time, and the judge gave the instructions on punitive damages. And what do you think happened? The jury came back and awarded those 5 nice people, I hope they're nice people, $500 million from Johnson & Johnson. I do not know if they ever got that money, but they got an award of that much, and then Johnson & Johnson appealed, and I don't know what happened from there. I do know that one appeal was granted, but it had nothing to do with the money. It had to do with one of the witnesses was a little tiny bit, one of the witnesses for the plaintiffs, for the people doing the suing, their expert witness was a little bit dishonest in describing how he had gotten on board the case. So, but my point is, well, what happened in the next case? Well, the next case was about 6 months later, another 5-pack. It was done under slightly different reasons because they were from different locations, and those locations supply the rules that the trial will go under in federal court. So it was actually from around here in California, and the jury not only gave them compensatory damages, $100,000 for Mr. A, $170,000 for Mr. B, $65,000 for Mr. C, but gave them punitive damages of $1 billion to split 5 ways. Holy cow! So Johnson & Johnson can't believe it, says this has to be a fluke, these have to be drunk jurors, can't happen, we don't know what to do. But I start bugging my lawyer and saying, are you preparing for the punitive damages aspect? When are we going to trial? Are we in line? Are we going to where? And I say, where's my file? I want my entire file. I have to see it. Did you take any depositions of the doctor who did my surgery? Did you get the bills for my revision surgery where they took the Johnson & Johnson out and put in a different one? And I keep asking him and going on and on and on. And what are you doing? And finally, they don't say anything, but his law firm sends me a thumb drive with the entire file on it, and it's only 50 pages. Just the letter that I told you about, the retainer, and a couple other little papers he'd filed with the court, some bills, and that was it. So he had done nothing on the case. And I have no reason to believe that my case is special. I would bet that means that his buddies and he have done no work on any case. And that's why my case was never in line. You can't get in line and then show up to trial and say, Your Honor, I don't have any evidence or anything. I didn't do any work on the case. Because they will just say, well, then in that case, you're non-suited. And you owe the defendant, Johnson & Johnson, their attorney's fees, which would be hundreds of thousands of dollars. So what did my lawyer do when he knew I was digging under the fence like a crazy dog? I now knew something was really wrong. And yours may be in the same situation. Well, when my lawyer realized that I had him and that I was saying I'm going to the FBI, if you don't show me some work, I'm going to say you've done this and lost the 200 cases that you're stepping on. Now, maybe the other lawyers are not flakes and are not letting the case turn to dust in front of them. But I said, but I have no reason to assume the other cases you've got are any different, and that would mean that there are 200 cases where you're losing $100 million per case. So that's $200 million. No, wait a minute. That's $20 billion these guys have lost. You know how long they go to jail? Now, remember, the public doesn't know this. This is still happening. I'm not saying this happens, whatever, and it's a great story. This is happening now. Your case, if you have a Pinnacle case in the Fifth Circuit, and your case may be one of those. Now, I'm not naming any names right now because since I don't have any proof in front of me of any of this, I want to make sure that nobody can sue me. This is just, I'm telling you my experience and what happened to me. And when I say it could happen to you, that's just based on my advice that it could happen to anyone. There's no reason why this can't happen to your case. But what I'm really saying is you'd better check your case. So the way my case ended so far was that they said, well, we went to, hey, dude, we did a great job. We went to arbitration, which the court ordered of all cases. We got you $70,000. And I said to him, you got me $70,000 with no bills and no doctor reports from my surgery. If you would have done this case upright, I would have gotten $2 million. And they don't answer. They're smart enough not to answer. They just say, well, we think we did a great job. Fuck you. So my lawyer at that time, now when he got there, he did the right thing. He really did. And I respect him for what he did. Not many people would do this, but he actually, rather than standing up and saying, you know what, and going to the court and saying, Your Honor, I screwed him over. I really did. Your Honor, I would like a chance to hire another lawyer to represent him out of our pocket, which is what they should have done. And, Your Honor, I will accept any punishment the court imposes. So that's what he should have done. And you also ask for the discovery deadline, if there is one, which I don't know. But if there is one, that it be wiped out so these guys can start doing discovery for real. Well, that's what should have happened. But instead, my lawyer killed himself. At least that's my belief. He was working on Friday, and on Monday there was a hushed, he's not here anymore. And I looked everywhere to find out the cause of his death. No place listed the cause of death. And when that happens, and there's none of those send flowers and donations to the Lou Gehrig Foundation or the Syphilis Sufferers Foundation, that means the person killed himself and his family doesn't want it known publicly. So he did, and now that leaves me with just an action against my previous lawyers, saying that if you had done the job right, we would have gotten hundreds of millions of dollars, which is almost impossible to deny. Is your case, like mine, already lost? And they haven't told you. They're just jerking you along, hoping that you'll settle the case without reference or without incorporating in a huge amount for punitive damages, and hoping maybe you don't even know about the punitive damages. So the punitive damages at first was the thing don't fit, and then a second set of whistleblowers at Johnson & Johnson revealed that all Cobalt appliances hurt. And Johnson & Johnson knew this when they were selling them in 2008, which is when I got mine, and that the pain I felt was to be expected. You put a Cobalt hip in, it's going to start destroying the surrounding tissue right away. It turns to like a black oil, and your beautiful tissue that works your leg turns to shit. And they knew that. More punitive damages. So that came, and so what's happened since then is that there have been 3 more 5-packs. That's where the 5 litigants go in, present their cases through their attorneys, and the juries on each one gave $500 million to the 5-pack to split 5 ways. I can pretty much guess. I don't know. My lawyers, the lawyers who took over my case, in other words, his boss or whoever at that flaky law firm, say that none of these people have ever really gotten that money. that they get that Johnson & Johnson appeals and I've tried to look it up. I don't know the answer to that. But it sure is a bargaining position when the man or woman from Johnson & Johnson comes over and gets on the phone with you and says, hey, you want to settle the case? You've got specials here of $135,000. How about we'll give you a very generous $500,000? That's something, huh? And you say, no, that's nothing. We're going to go to trial. We're going to take you for $150 million plus $500,000 compensatory damages. Well, we don't believe that. And you go back and forth, but it is a great bargaining tool, and you can really get the offers up if you know how to correctly use the threat of punitive damages. Well, we're out of time. All right. I will see you next week. Before I go, here's what you have to do for next week. Get your total file from your attorney, every paper. For convenience, see if they'll put it on a thumb drive. That's pretty nice. If not, you can take it on a disk. But a thumb drive would be really great if you could get it on that. And we're going to look at it next week. I'll be here. You'll be out there listening with your file and going over it. And I'll tell you what we're going to go over and how to determine if your lawyer has dropped the ball and is hiding it from you, or if your lawyer actually has successfully and competently prepared your case for trial, which would really be nice. That would be great. Even if you've settled your case, you might be in a position to do something, and we'll talk about that next week. I'm Glenn. Go down there and hit the button that says thumbs up, hit the bell, and I'm going to see you next week.